When should you get an emergency custody order? I'm going to walk you through the basics. I'm Caitlin Fox. I've been a family law attorney for 8 years. If you have any questions about emergency custody orders, leave them in the comments. An emergency custody order is ordered when there is a situation that requires immediate attention. The purpose of these orders is to address this immediate attention or this immediate need before the court, before a full hearing may have happened, or before both parties have an opportunity to speak on the matter, because there is an urgent need to address the issue. When is the right time to file an emergency petition? As soon as possible, as soon as you know that there might be some sort of relief needed to ensure that the court has an opportunity to hear your case and to ensure that your case does not linger before it's heard before the court. What are some of the conditions under which you can file for an emergency custody order? Some of the conditions that might allow you to file for an emergency custody order would be potential drug use by one party, or one party is currently not housed, and you need immediate relief to ensure that the child is housed. Another example might be that there was some domestic violence issue, either towards the child or towards a parent, that warranted some immediate relief in an effort to remove a child from a situation where they might be in danger. But typically it's going to be an instance where there is a danger to the child, whether it be a parent putting them in a difficult spot or a grandparent putting them in a difficult spot that could lead to a dangerous situation for them. What does the process of filing for an emergency custody order look like? Is typically a quick process. You are going to do this quickly because there is an immediate or emergent need. So typically you're going to go to the courthouse and request your relief. You'll go to the courthouse with your petition, or you'll file one there. You're going to likely see a judge or a custody master or hearing officer, and they will either grant you the relief or they will schedule you to come back. And typically at that point, the other side is going to have their advance notice to attend a subsequent hearing. They'll also have an opportunity to have their side heard. But when you're requesting an immediate order, you're typically requesting that the judge enter an order without hearing all sides. It's called an ex parte order. And when that occurs, they're usually just hearing you out. They may enter an order which stands in place until there's a subsequent hearing where both parties can then be heard. What to expect during an emergency custody hearing? You should expect to lay out your case with as much evidence as possible in order to inform the judge of why immediate relief is necessary. And a judge is going to ask you why it's important, why there is such an emergent need, and why they should enter an order that day rather than waiting to hear the other party out. So you should expect to bring evidence, testify on your behalf, and explain to the court why you need help right away. After the action is granted, what's next? So if you get an emergency custody order in place, you're typically going to need to serve the other party, and that subsequent hearing will take place. And from there, an order will either be entered on a final basis or it won't be. But from there, you'll likely have to go through the rest of the court process in the family court and have a court look at all of the evidence and documents or, testimony, and determine a final custody determination based on all of that.